Hi, everybody. Welcome back to the Children First Family Law podcast. I am very humbled and honored today to have with us Forrest Mosten. Many of you may not have heard of Forrest, but you should have, particularly if you're a family law attorney, professional judge, because he truly is an icon. And he is going to talk with us today. He practices out of California and has decades of experience and is going to talk to us about peacemaking and being a peacemaker, which frequent listeners will know is right along my motive in family law entirely. So, Mr. Mosten, thank you for being with us.
Krista, I'm honored. I'm delighted to be able to talk with you. And I understand we're only limited to 6 hours today.
Totally. Everyone's used to me being very long-winded. Lawyers like to talk. So tell people a little bit, let's go like way back, okay? Because I know you made so much, it made and have been making and are still making. I'll tell people who are watching on video and read for my audience on audio that gracing the screen behind Mr. Mosten is his book, Family Lawyer as Peacemaker, which I'm like, here, every lawyer should go buy that. And actually every parent should go buy that for your lawyer, right? And judges should read it too. It's the kind of approach you all should be taking if you're going through the sad situation of post-decree or pre-decree divorce. But let's go way back, because I know you started as a litigator, a really good one at that, in California for a very long time. And at some point you said, this is not working for families and we need to do this differently. So give us the framework of that, of what you kind of started out as a younger lawyer doing.
I was doing what all family lawyers did, is that we were both solicitors and barristers. We virtually used court as a leverage and power for negotiation. It's the way I was trained. It's the only way family lawyers worked at that time. So right now, I have this totally different practice. I haven't gone to court in over 30 years. And people wonder, my gosh, how would I eat 3 times a day? How would I have a roof over my head? And it turns out you make a lot more money when you do not have to go to court. And the reason is that people are satisfied and your bills stay down, so they get paid and you don't get burned out.
So I've done podcasts before on collaborative law. I am collaboratively trained too. And so I'm a big believer in it. That one of the catches, though, that I want to make sure people are aware for that Forrest just discussed is everybody agrees you're not going to be the lawyers that go off to court if you're the collaborative attorney. That's why we're discussing this method of saying, hey, why don't we step away and let the collaborative lawyers do their thing? It's because those collaborative lawyers, as part of the collaborative agreement, will not be the ones that go litigate for them. So just making that point for people if they're confused about that. But yeah, I mean,
that clarification.
Mhm.
And it's very important because the first reaction of many people and of most traditional lawyers is that you abandon your client, that the client doesn't have the same lawyer all the way through. And I'd rather reframe that and frame it where there is no incentive for a collaborative lawyer to overplay the
That's true.
litigation or the power and leverage.
Yeah, because they're going to get fired.
In my mediations, for example, clients don't have to do this, but they have an option. They can sign an agreement that says if the mediation doesn't succeed or terminates, then their lawyers are terminated too. What an incentive for the lawyers to work that much harder, because no lawyer likes to get fired. Krista, I will talk to you about another protocol that I developed about 10 or 15 years ago that just turn my practice into a rocket ship as far as clients. When I refer as a mediator, the parties to a particular or 2 or 3, say, accountants who wield a tremendous amount of power in their reports. I like these accountants. I've worked with them before. I have trust and confidence in them. I think they are competent and they are nice. But you know something? Clients may have different view. My view may not be their view. So you know what they do? With my help, they interview all 3 accountants, 15 minutes each. It's like speed dating. They're able to read this is on Zoom. They're able to read the face of the accountant. They're able to hear them answer questions that I prepare and help them ask. And at the end of the time, they will choose together their accountant. I do the same thing when they're choosing consulting lawyers, and I'm the mediator. Often, I believe they should have consulting lawyers, almost always. But they should pick them. And get this, they both have to agree on the 2 lawyers that will represent them. And they have to agree who will represent mom and who will represent dad. So if mom's lawyer makes the request, I didn't say demand, and the lawyer doesn't, and mom and dad doesn't like it, dad has only himself to blame because he helped choose that lawyer. Can't blame the lawyer. And so I have found that it creates sort of a community within the mediation room that really works out very, very well. And the extra cost for the clients is 1 hour of my time. I've got a magical friend. Yeah, magical friend sits right on my desk. Her name is Marion. Marion lives with a peacemaker heart in an adversarial world. Marion feels very, very isolated. Doesn't have other lawyers like him or her to play with. So that is how they form study groups in that community or with me. That is how they take and join the right organizations, and they learn something. They make more money when they don't litigate than when they do. For 2 reasons. One, it's hard to be a little here and a little there. It's hard to be an adversarial barracuda on Monday and a peacemaker on Tuesday.
Yeah.
I'm a peacemaker all week. So I'll give you a second story. The biggest, and I have permission to talk about this case, the biggest collaborative case in history is Roy Disney, who was my client. I represented Roy, and how did I get the case? His business lawyer took my mediation course and asked me to be his lawyer. But I needed a collaborative partner. And the only collaborative partner that his people, people wanted to have was a really well thought of litigator in Los Angeles. With not 1 minute of collaborative training and not 1 minute of mediation training, but a good heart and a desire to have this job. It was a big job. And he said, okay, I'll just need this. This is, to his credit, a little mentoring. So I did a little mentoring, but I represent the other party. But so did members of my collaborative practice group. He hired another collaborative lawyer to teach him a bit about, I'll give you an example. What's different? If you make a mistake, you're the other lawyer now, Krista, and you make a mistake in my client's favor, either you got the law wrong, which sometimes happens, you got the math wrong, which sometimes happens.
Which happens often. Yeah.
It is my job as a collaborative lawyer to point out that mistake, even if it hurts my client. Yes,
Yeah. I mean, 100%. You should anyway.
I would never,
Yeah.
never misrepresent
Yeah.
my collaborative partner, because all I've got is my word
Mhm.
and my reputation and their trust and confidence.
Mhm.
If I ever misled them, I wouldn't be on another collaborative case. And so we work together out of trust and confidence,
Mhm.
and our clients appreciate it.